pretty hard act to follow, Vinod. I'm not sure whether to thank you or to curse you. I think I'm thinking about that student that you were talking about who is feeling so overwhelmed. I don't begin to have many of the causes for feeling as overwhelmed as she does, yet after your talk, I'm feeling fairly overwhelmed. It's hard, I think, to follow what you've been, your presentation, because I think a lot of what you said was so profound. The sense that this disjunct between the notion and the idea and the theory and the fantasy of our Constitution and all that it represented and the hopes that we have invested in that document and in a new constitutional democracy, that's versus the practical, factual reality of where we see ourselves and what we face in our society is so stark that it is, for me, overwhelming. And I think you've reiterated that in very, very forceful terms. You have touched in some ways, and I think everybody has in some way touched on quite a lot of that I want to say in my presentation, which I think is really just going to be perhaps some practical reflections on what access to justice means in the South African context here and now, why it's so important to our constitutional project, who is responsible for providing access to justice, what does access to justice mean, and what is the role of lawyers, perhaps. And perhaps just interesting listening to some of the questions that have been asked. For example, what is the role of global corporations or just other corporations, or perhaps simply non-state entities in this notion of justice and access to justice? And is there a role to be played by civil society? And that's something that I do want to touch on, because I think it's very important, and I think it's something that's very neglected and has been very neglected in the jurisprudence and in the struggle, I think, thus far in promoting constitutional justice in our country. And I'm wondering why, because I think that the Constitution itself actually provides for it in some ways, and yet it's a very unexplored issue in our society and in our courts. So, access to justice. I think that Vinod has very powerfully basically summed up that access to justice is not just about the provision of civil and political rights, and that in the South African context, access to justice to a large extent is really about dealing with trying to transcend socioeconomic inequality that we face, the very stark socioeconomic inequalities that we face in our nation, and this, I think, is something that I think that Vinod has presented not just because it's a necessity, and it is a necessity. I think it's something which is essential to the survival, quite frankly, of our constitutional project. I think that if we do not move forwards in addressing socioeconomic inequality in our nation, I think we face a very stark future. And it is so fundamental, I think, at this stage to the continued rule of law, quite frankly, the continued success of a nation governed by rule of law, that it is not something that we can pretend to overlook or not seriously consider or deal with. How we do that, I'm not quite sure, especially after everything that you've raised, Vinod. But I think what I do want to emphasize here, perhaps, is the fact that the drafters of the Constitution themselves recognized, I think, the importance of socioeconomic transformation, and that is, and I think it's something that Judith has already raised and dealt with, is the fact that ours is a transformative constitution, and it is very expressly and avowedly so. It's not that that there are just one or two constitutional court judges or people who've suggested that is in fact the case. The preamble itself and many of the provisions of the Constitution make it quite clear that it was intended that the Constitution is a deeply transformative project which is intended to promote social justice, transformation, and substantive equality, so that we're not just dealing with formal realization of rights, but actually dealing with the substance of the differences the acute stark differences that we face in our society. So it is avowedly a constitution that is designed to promote and facilitate substantive justice. And for this reason, I think our Constitution is a remarkable Constitution. It is a deeply sophisticated Constitution. It is perhaps a Constitution that is way too sophisticated for the developmental stage that we find ourselves in, actually in our society. And in some ways, I sometimes wonder if we haven't set ourselves up by creating such a sophisticated document, and perhaps we're struggling to live up to the expectations that have been created. What do we? So in that's the context within which I'd like to suggest that by access to justice, I think we're not just talking about the idea of formal equality. To what extent does, and what is the role of lawyers in providing for access to justice, or assisting in providing for access to justice, to the facilitation, to the provision of social goods and equality in our nation? And is access to justice, is there an enshrined right to legal representation or access to justice in our Constitution? And this is something that I think that lawyers need to be grappling with and thinking about. It's not something that, beyond the context of legal representation in the criminal context, is something that has been given very much thought. So we have Section 35(3) of the Constitution, which clearly makes provision for the right to legal representation on the part of an accused, where the legal representation provided by the state in circumstances where failure to provide legal services would amount or give rise to substantial injustice. So that is a provision that is clearly provided for in the criminal context. And I think that is partly historical, because we come from, once again, I think that the history of the apartheid system, where based on the apartheid laws, we had hundreds of thousands of people who were convicted for sometimes crimes which were politically designed crimes with no legal representation, and sometimes with dire consequence. We had a situation where we had a death penalty, where people were being committed to death without the privilege of legal representation. And so I think that the Constitution was, I think the framers of the Constitution were clear that had to be addressed. And I think that was in some ways seen as the most acute need in terms of access to justice or provision of legal, the right to legal representation in the Constitution. But what about the rights of individuals, of citizens in a civil context? Does the Constitution make provision for, should there be provision for the rights to legal representation in the civil context? That's something which is a lot less clear in the Constitution. We do have the rights that Judith has already alluded to, I think. Oh, no, it was Vinod, actually. Somebody has already alluded to the right to access to court in Section 34 of the Constitution. And if I could just read that out to you. Section 34 of the Bill of Rights says, everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court or, where appropriate, another independent and impartial tribunal or forum. You will see that the right really effectively is to have a fair trial, a public trial, in front of an impartial forum. There is no mention, there is no express mention of the right to legal representation. The question is whether or not that right is implicit. Can you, in certain circumstances, have a fair public hearing or without legal representation? And I think the argument that is made by a number of commentators is that in the South African context, where you have, I think it's something like 54% of the population who live under the poverty line, people who are struggling to find food to put on the table, people who are very often illiterate, who have a very little education, to expect that they would be able to go to court and assert rights and make sophisticated legal arguments before in an essentially adversarial court context, and do that effectively without the assistance of a lawyer is a pipe dream, really. And so if we are serious about the idea of there being a right to a fair public hearing in the civil context in South Africa, then by necessity in certain circumstances, we have to read in the idea that in certain circumstances there must be an obligation, perhaps on the part of the state, to provide free legal representation. So there has been a debate, but there are certainly arguments to be made, especially if you read Section 34 and the right to a fair trial. If you read that, I think, in the context of many of the other provisions in the Constitution, if you read it together with the idea that in terms of equality, everybody is entitled to equal access to all rights and freedoms. If in fact our Constitution is one which is committed to substantive justice, if in fact, in terms of Section 38 of the Constitution, you're entitled to an effective remedy and a just and equitable remedy, and that a court has an obligation to provide for a just and equitable remedy, then I think there's a very compelling argument to be made that certainly in certain circumstances there is a right to legal representation, and not just in the criminal context, but in the civil context, and especially in a situation where we understand that we have a transformative constitution which is whose purpose is to move us forward. So there's been very little case law on this question. There's been one case, I think, that was handed down in the land claims court, where a fairly progressive and activist judge reached the conclusion that Section 34 did give rise to rights to free legal representation, which had to be provided by the state in a certain context when it came to a matter dealing with the issue of land rights. This is it's not a decision that has been followed by any other court, and there are a number of commentators which suggest that the judge may have gotten it wrong. But I think if you read our Constitution in a purposeful manner, it is an argument that perhaps should be pursued more rigorously by people in other contexts. Whether or not the standard would then be the same standard as that applied in the context of a criminal process, and what the standard should be and what the test should be as to when we should be saying that there is a right of access to legal representation. Do we apply the same standard as there being a substantial, a threat of there being a substantial injustice if a person is not provided with legal representation? Is I think that is also something that needs to be debated. I think that one of the issues that one of the spectres that this obviously raises is the question of where do the resources come from? Where do we find the resources? Where does the state find the resources in order to provide for this right to free legal representation? And if indeed that is what was intended by the framers of the Constitution, would they not have made express provision for this as they did in not only Section 35, but interestingly in terms of Section 28 of the Constitution as well, which is the provision which provides for the rights of the child. And Section 28 deals very extensively with the rights of the child. There is a provision which also says that the child should be entitled in certain circumstances also to legal representation where this would be in the interests of the child. So there is once again another very specific express provision for the rights to legal representation in the Constitution. So that is once again used by many commentators who are against the idea of suggesting that there is a more free-form obligation, at least on the part of the state, to provide free legal representation in a civil context, suggesting that the text shows that that was not what was intended. But I think it's up to lawyers to be creative in this space. And that is something that I really want to raise and to deal with, is the question of the role of lawyers and the role of the profession in relation to access to justice. Because I also think that a lot of the conversation that we've had today and has been about the duties of the state and the role of the state and possibly the failures of the state in making advances, the advances and in promoting rights. But as a lawyer at the moment, I'm a partner, the pro bono partner in a big law firm, and it's something which I face daily on a daily basis, is the level and the extent to which there is a commitment on the part of the profession generally to promote and to provide pro bono legal services. It's a debate which is very alive at the moment in the South African context, the question of whether or not lawyers themselves have an obligation, and whether or not the profession has an obligation to provide or should be mandated to provide free legal services. There's currently no legislation which actually requires lawyers, whether it's attorneys and or barristers. So as somebody mentioned beforehand, in South Africa, we follow the split bar system. So we have solicitors and or attorneys, and then we have barristers and or advocates who are the ones who appear in court, which actually in some ways makes the legal process doubly expensive, arguably, because you have to employ two lawyers if it's an important case. There is no legislation which currently expressly provides that lawyers, either solicitors and or barristers, have an obligation to provide free legal services. What we do have at the moment is a situation where it's all in a state of flux, because there is a new act which has just been passed, a new act of parliament designed to regulate and to transform our profession, called the Legal Practice Act, which some provisions have come into effect, but a large portion of those provisions are not yet in effect, because there's a transitional process which is taking place. There is a legal forum which has been set up to try and create new rules for a new legal practice council, which is going to basically take over the roles that are currently played by professional societies. So currently we have a situation where the profession is regulated by, is self-regulated effectively by law societies which govern attorneys, and bar councils which govern the advocates profession. Both the law societies and the bar councils have all passed rules of procedure, or rules governing their own societies. And in the rules of both the attorneys and the advocates, they all both sets of rules in each province provide for provision of pro bono services by the profession. So in the context of the advocate's profession, there is a notional obligation that you should be providing 20 hours of pro bono legal services a year, and there's an obligation to submit a certificate to the professional bar society or the bar council every year to explain and show that you did in fact submit those services. The problem is that this is not properly enforced, and in fact the obligation, if indeed you can simply say, well, nobody actually came to me and asked me to provide pro bono services, all your obligation really do is to render the certificate, and it will only be unprofessional conduct to not provide the certificate and not to have actually not provided the services. As far as the law societies are concerned, it's in most provinces there is an obligation in terms of the rules, if you're called upon to do so, to provide 24 hours of service, pro bono legal services a year. Once again, it's not something that is actually ever enforced. And so, although people are meant to submit certificates when they have provided the services, once again we have law societies which are wholly inefficient, and which I don't think there's ever been one instance of anybody being disciplined for failure to provide pro bono legal services. The question is whether or not, and there is a big debate which has been going on for years, and which has gone on and continues to rage in the context of the adoption of this new legal practice bill, as to whether or not there should be a mandatory obligation on the part of the profession to provide free pro bono services. My argument is that yes, it should be. That it's not only a moral and ethical obligation of lawyers who are not meant just to be people making money in big corporate law firms, but are people who have an obligation to promote justice, who are officers of the court, and who are agents of change and should be agents of social justice. But it is something which is deeply controversial. There are arguments, there are a lot of lawyers who suggest that it's wrong to expect, it's like trying to draw a free tax from lawyers, for example. And why is it that only lawyers need to provide community service and not architects, for example, or doctors? Well, in fact, doctors are required to provide, I think it's 1 or 2 years of community service. And the idea that in fact, you wouldn't want to be unleashing a corporate lawyer in a criminal context, so there are 101 different excuses which lawyers will come up with as to why there should not be an obligation to provide free legal services. I think that what is wholly absent in the debate is the question of to what extent there is actually a constitutional obligation, not just a moral and ethical obligation. And then that's where I come to this whole question of the horizontal application of our Constitution, which I think, and our Bill of Rights, which I think is something which is relevant, not just and it goes back to the question that was asked, I think, a little earlier around, well, what about the obligations of corporate society or global corporates and in the South African context? Is there any way in which the court or any of our courts could be forcing, for example, corporate entities to be taking some kind of responsibility for effecting social justice and effecting socioeconomic change in South Africa? And I think the answer is yes. And I say that because, and I'm not sure if Justice Madlanga has raised this with you at some stage yet, for those of you who are attending his courses on constitutional on our Constitution, but one of the sophistications of our Constitution is the fact that it is horizontal in application, in certain circumstances. So it doesn't only, in terms of Section 8(1) of the Constitution, it doesn't necessarily only place obligations on the state, so the state vis-a-vis citizens, but in fact, in certain circumstances, what Section 8(1) of the Constitution says is that in certain instances, certain rights are also horizontal in application, so that in fact what the Constitution does in certain circumstances and what the Bill of Rights does, it places an obligation in fact on private individuals, private corporate entities, okay, to promote perhaps respect and fulfill the rights in the Bill of Rights. And the question that I think needs to be explored by the profession and by those who are wanting to hold the profession accountable is the extent to which one could make an argument that, in fact, based on the right to Section 34 and perhaps other rights in the Constitution, there is in fact an obligation, a constitutional obligation, which could be enforced in certain circumstances, requiring the profession to actually provide legal services and to assist in providing access to justice. So that is certainly not an argument that most lawyers would want to entertain. But I think it's something that needs to be considered, and it's something, I think, just harking back to Vinod's address, that, I think the issues of inequality in South Africa are so stark that the question of and the how and if and when and in what circumstances we can possibly be holding civil society and corporates and accountable under the Constitution in terms of horizontal application is certainly something that we need to be considering. Thank you.